Namaste students, I'm Professor Dr. Pinarivan. Today we will be discuss about arbitration proceedings under section 19 of the Arbitration and Conciliation Act 1996. Section 19, Arbitration and Conciliations Act 1996. Section 19, Determination of Rules of Procedure. And second content, arbitrator not bound by Civil Procedure Code, CPC. And third one, no Civil Procedure Code arbitration. Right? Inexpensive arbitration. Arbitrator to take evidence. Award by consent. Section 19 of the Arbitration and Conciliation Act. Determination of rules of procedure. Opinion. Arbitration proceedings are not bound by the code of CPC 190A, Indian Evidence Act 1872. If the provisions of this part do not differ, the parties have the right to agree on the procedure that the arbitration code will follow when resolving the case. If the agreement refers to in subsection 2 is not reached, the arbitral tribunal may, according to the provisions of this section, conduct the case in a manner it deems appropriate. The arbitral tribunal has jurisdiction to rule on the admissibility, relevance, importance, and weight of any evidence. An arbitrator not bound by the CPC 1908 subclause 1 of the Act makes the same provision with a special law such as the Act 1996 provides for the resolution of certain issues. A procedure similar to civil law can be applied. The arbitrator is not obliged to formulate the questions because he is not obliged to follow the procedure defined in the civil code. Arbitrator need not follow technically of deciding cases under Rule 1 of CPC. It was held in this case, the case name was Ashok Kumar Singh versus Shanti Devi, AIR 2011. The arbitrator is not required to address each claim or dispute separately, and he does not need an award formally stating the arbitrator's decision. each dispute. Arbitration not governed by the Evidence Act. An arbitrator not bound by the civil procedure. Section 19, subclause 1 provides the Act meet the same provision. A special law such as the Act 1996 provides for the resolution of certain issues. A procedure similar to civil law can't be applied. The arbitrator is not obliged to formulate the questions because he is not obliged to follow the procedure defined in CPC. Arbitrator need not follow the technically of deciding cases Rule 1 CPC. It was held in Ashok Kumar Singh versus Shanti Devi 2011. The arbitrator is not required to address each claim or dispute separately. And it does not need an award formally stating the arbitrator's decision in each dispute. Arbitration not governed by the Evidence Act. In the case of J.K. Cobor, versus F. Khambhatta, 1930, the court said that an arbitrator does not have to follow the technical provision of the Evidence Act, and his award can't be challenged on the ground that he relied. A document not governed by this act may be admissible. The powers of the arbitrator are limited only by the fact that he must not violate the principles of natural law. He must listen to the parties and give them reasonable time and opportunity to justify their arguments. IOC Limited versus Must Engineering Entrepreneurs 2008 found that the failure of the arbitrator to review the document can't be a basis for annulment of the award because the arbitration is not subjected to strict rule of evidence. Affordable arbitration. In Union of India versus in Single Builder Syndicate, the case 2009, Supreme Court held in this case that when a court orders an arbitrator fees without disclosure, both parties or at least one party are at a disadvantage. First, the parties feel compelled to accept the fees proposed by the arbitrator, even if they are large or expensive. Secondly, if the arbitrator demands large fees and one party is willing to pay them, the other party who can't pay such fees or is unwilling to pay such high fees placed to an awkward position. He can't express his doubt because he subjects that refusing to pay might harm his position or create a prejudice in favor of the other party who agreed to pay high fees. The duties of the court from the point of view of the expediency of handling the case are to handle the case in a reasonable time, participate in hearing and participate in negotiations according to agreed procedure, and handle all cases. Arbitrator to evaluate evidence. The evidence used by the arbitral tribunal must be such as is consistent with the principle of mutual justice. Lord Denning, Centrex Gears Limited versus Metro Limited, 1976. In this case, noted that the weight of the evidence and the conclusions drawn from it are essentially questions for the arbitrator. I don't believe that the arbitrator's decisions should be challenged or set aside on the ground that the evidence was insufficient or too weak or similarly. One reason for arbitration is to review the technical risk of the evidence. Question of evidence are essentially questions for the arbitrator, not the court, whether or not a particular document is relevant and should be submitted to the arbitrator. It's essentially a matter for the arbitrator to decide, and any decision to the arbitrator make is binding on the party. Documentary evidence is within the jurisdiction of the arbitrator and cannot be the basis for making an award. Where a party desired the arbitrator to delay an award until he had satisfied him to some matter, which the arbitrator had found against him, and because it was within two precedence or 3 days before the expiration of the time limit for making an award, the arbitrator rejected his request and gave his award, and it appeared that there was cause to be heard at the request of the appellant, although it did not appear that he was prepared to be heard within the time limit. The court set aside award. Arbitration Proceedings, Section 20 of the Arbitration and Conciliation Act. Arbitration Proceedings, Section 20 contains place of arbitration, appropriate venue, choice of venue by the parties, arbitration, venue according to law. So, Section 20 we will be discuss tomorrow. Thank you. Thank you so much.